Here's an update on the Kansas City accountability arrest in Des Moines last month. As I'd mentioned, back on April 8th, our auditing friend Angel Moses from Kansas City was charged with interference with official acts, and that's under Iowa Code Section 719.1, purportedly for declining to identify himself, as he was peacefully shooting video from a public sidewalk, what the U.S. Supreme Court calls the quintessential public forum. Now, Angel was booked and released on $300 bond, filing a motion to dismiss during that hearing, which was set to be heard during pretrial May 13. But in a new development, Wednesday, May 7th, as you can see here, prosecutor Joan Nearing has filed a motion to dismiss with a notice of intent not to prosecute. But instead of hearing prosecutors' motion to dismiss the pretrial conference, the court immediately dismissed the charge, effectively canceling the case. And I think it's interesting the court makes the criminal defendant wait a month to be exonerated, but the prosecutor gets same-day service in its motion to dismiss. But here's the thing. What's crystal clear here is that the government knows it shat the bed. What the prosecutor's doing here is taking that criminal charge on the proverbial walk of shame. Here's what we know about that Peeping Tom trespass law that Officer Williams was talking about. 716.7(1)(f) defines reasonable expectation of privacy, while 2A7 forbids photographing and filming through the window of a dwelling without a legitimate purpose while on the property of the dwelling. The person has a reasonable expectation of privacy and doesn't or can't give permission. But we're talking about a public sidewalk here, and that's not the private property of a dwelling unit. And a person looking through a storefront window is not exactly a peeping Tom. Cambridge defines dwelling as a house or place to live in, synonymous with abode, domicile, habitat, or home. A dwelling is decidedly not a place of commercial business. And there's another privacy section in Iowa law, this one under Chapter 709. Iowa Code 709.21, Invasion of Privacy and Nudity. Nothing Angel did outside that central bank branch rises to the level of invasion of privacy. But cops charged Angel with interference because he declined to provide his details as requested. But you probably understand that even in a stop and ID state, police have to have reasonable suspicion that the individual in question is involved in criminal activity. In this case, Williams thought the Peeping Tom trespass was his golden ticket to collar a perp. And now we know Williams' plan wasn't very well conceived. Couple of questions remain. Whether Angel files a Section 1983 federal lawsuit against the city and the police department, and what corrective and disciplinary actions are being taken by the Des Moines Police Department against Williams and Neary for their handling of this suspicious person call. I'd love to ask the officers, what the hell were you thinking? Should have just walked away. But it'll be interesting to find out what professional standards Des Moines Internal Affairs has to say about that.